topic for today is company formation. So we're going to see how one can actually go out and do one of these things, set them up. You will remember our toilet-obsessed inventor friends, Yorgos and George. Now, they both have got this idea that their toilet flush is a fantastic idea. It's going to make them very, 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 very rich. And they're thinking about how to actually go about bringing this to market, but do it with the protection of a recognized form of business organization that entitles them to both structure their relationship with each other plus their relationships with the outside world. They have, though, a series of options that are going to be a little bit confusing for them if they haven't been as lucky as you guys to take this class. You can just do the stuff. You do it. You go out, you sell it. You got like a pair of shoes you don't want, you put them on eBay. It's not the end of the world. It could be that you bought the shoes, you decorated them, and you put them on eBay. They could just do it. The problem is if, as we said, they go out and just do it, then if there's any issues of liability, if there's any debts to cover and so on, there is no separation between the business activity, their personal activity. Also, if Yorgos and George diverge in their interests, in their objectives, they start telling different things to different clients and doing deals, this might unbalance their relationship and it might make one liable for the debts of another. This might not necessarily happen if they're trading as self-employed as rather distinct entities, but if they're perceived to be a partnership, then what one does carries consequences for the other and vice versa. They might therefore choose to incorporate. Incorporating might be the more sensible or the more mature or the more thought out option here, even though I have to admit people will normally start operating as a partnership and then think about incorporating further down the line. But if Yorgos and George have been in touch with this material earlier on, they might think of actually structuring the things in a form of corporate, or taking a corporate form from the very beginning. We're having the assumption here that they're in it to make money. This is not, structured formations that are of a money-making nature. They will need to choose between an unlimited and limited company. They wouldn't really go for unlimited company because they could have achieved that by trading themselves or trading as a partnership. They probably want the additional benefit of a separation of their personal assets from their business assets. So you would expect them to go for a limited company. This limited company can be limited in two ways. One would be to limit it by shares. One would be to limit it by guarantee. If you create a company limited by shares, you can say this company consists of 100 shares of £1 each. And then Yorgos gives the company £50 and buys 50 of those shares. George gives another £50, buys the remaining shares, and they then have an equal proportion of shares. They are 50-50 shareholders in this company, and the money takes that money and puts it in its pockets, which is a separate pocket than the pockets of Yorgos and George individually. That's the whole point about the private limited company. So this then becomes capital of the company, this initial contribution of funds. They could, on the other hand, do something registered by guarantee. If you register by guarantee, you don't give the money up front, but you undertake a commitment to contribute to the company's assets at a set amount if the company goes insolvent. Now, why would you do this? You may not want to give the money up front, could be one reason. It also gives you a wider menu of options if you want to get out, because if you're a shareholder in a company and you don't want to be a shareholder anymore, you need to find somebody to transfer the shares to. In a private limited company, this implies the cooperation of the company as well. If you are a member of the company in the sense that you provide the guarantee, you can get out of it by resigning this, and it's a slightly different process. It might make things easier. On the other hand, if you have a profit, if you're setting up a profit-making enterprise, you're better off having a company limited by shares. The reason is that the shares give you an easier avenue to distribute profits, because you could either sell the shares at a higher value than the ones that you bought it if it reflects a growing, successful company, and also you get dividends out of the shares if the company is successful and decides to give money back to the shareholders. If you are a participant in a company by guarantee, then you don't earn anything because you don't participate in dividends or anything like this. If the aim of setting this up is profit making and you want a ready-made mechanism for the distribution of profits in a predictable way, I'm not saying here that the payment is predictable because you don't know if the company is going to make money or not, but the mechanism for making the distribution is predictable. Then you should be going for a limited company and a limited company by shares. Will your company be private or public? At the initial stage, it will be private. In our scenario, with the two inventors bringing their product to market and so on, the logical sequence is that they get together, they start the business, they incorporate a private limited company. If it starts growing and it becomes successful and they need outside investment, then they decide to go public. Remember that public does not necessarily mean listed in the stock market. So a company will need to become a public company that then the public at large can purchase its shares. If it wants to make the extra step, then it becomes listed in the stock market. That provides like this ready-made mechanism for participating in the buying and the selling of the shares more easily. The practical things now. What should they call it? Should they call it the best, most successful toilet experience you've ever had .ltd? Should they call it something really fancy that's gonna stand out? Probably not. Now, this is important stuff, right? Because what you call your company is very significant in terms of branding, and branding is important for marketing. The way you attract your customers, the way that you become known will have a huge influence on how you carry on your business. But this is important for the law as well. And there are checks from Companies House when you're trying to set up a company in helping you choosing an appropriate name, or if you want to see it in other ways, preventing you from choosing something that's not really going to work or it's going to create confusion. So there are a number of restrictions and controls in the choice of name. You can find those in a statutory instrument called the Company and Business Names Miscellaneous Provisions Regulations of 2009. What it basically says is that certain expressions and abbreviations you're not allowed to use. So you cannot call your company George Public Limited Company Ltd, because it ain't a public company. So you cannot use things like a designation of business format in the name, because that comes afterwards by necessity to alert people as to the sort of business you have chosen. So you cannot call yourself the Great Public Limited Company Ltd. And I'm talking about these designations in English, but also in Welsh, right? So you cannot use something that will suggest a form of business organization in Welsh either. There are also controls over the characters, signs, symbols, and punctuation that you can use. So, things are understandable and also machine readable, which becomes very important these days. Equally, there are some restrictions in the Companies Act. For instance, if you look between sections 53 and 55 and also 1197-98, there are restrictions there in saying that you cannot use anything that implies affiliation with the government or official service. You cannot call yourself Her Majesty's Toilet Flush Service. Anything that implies that you are a government body or a statutory body will be rejected. There are some trademarks that you can have that can use words like ministry and so on, but a trademark registration, right, is not the same as a company name registration. So I doubt that you would manage to set up a company that calls itself a ministry of some kind. Yeah. Also, you cannot use names that would constitute an offense or encourage people to constitute an offense. You cannot use offensive names. If you try to use certain things that are inappropriate, they will be disregarded. Also, you cannot use stuff that are very similar with something else, apart from not implying association with the government or an official institution, and not using something offensive, not saying something that implies a different form of business organization. You're also not allowed to register something that's very close to an existing company. This is not like domain name. Things are more restrictive here. if you want to call your company, like Flushes Limited, you cannot put Flushes with 2 S at the end, Limited, and say, yeah, this is my Flushes. There's another Flushes out there, but mine's different because it's got 2 S's. Because people are going to say it's too close and there's a risk of confusion. So you cannot play with capital and small letters. You cannot play with adding random letters left and right if people are likely to make the confusion between the name that you're choosing and a different name. Now, there are some exceptions. The exception could come primarily from the fact that you've operating for a long time with this name before you incorporate it, so people know who you are. If that's the case, it might allow you to incorporate with a name that otherwise would have been rejected because, again, there is no risk of confusion. The registry will refuse to take, the company's house will refuse to take an application with the name that they object under any of those grounds. They're going to ask you to find something else. They will be particularly unhappy if you are misleading with the name about the sort of business that you're engaged in. Because we said we do not want confusion, but we also don't want you to have an original name that actually suggests that you do something else from what you're actually doing. If it is deemed that you're trying to deceive people as to the purpose of your firm by using a name that's got absolutely nothing to do with it, you might be refused. Also, you are not allowed opportunistic registrations. So you cannot go register companies with a bunch of names that you think people might want to use in the future, so then you sell them the company so then they can use that name. You're only allowed to register a company if this is a genuine attempt to actually run a company with that name. They will not allow you to reserve names. So you cannot reserve a name in the process of registration to make sure you don't lose it. No, if somebody gets it before you, that's the end. And you're also not allowed opportunistic things. Again, this is not like domain names. You can do this with domain names and then sell them to an interested party if they want to buy the name. You're not allowed to do this with companies. Should distinguish company names and business names. Business name is the name that you're known with. It is a label under which you do business, but it is not an official thing. So it could be that for years you had a corner shop or you had a kebab shop that called itself Best Kebab. A business name would be like Best Kebab, but it's not registered anywhere. It doesn't represent the name of the company. You are looser in what you can do with business names. And somebody operating as a sole trader, normally they operate under some banner. They wouldn't go like Yorgos and George, the guys who make the toilet flushes. They would probably have Yorgos and George Flushes. Business name normally precedes the registration of a corporate entity. People will usually carry on the business name. They will seek to have that business name as the name of the company thereafter. There are, again, some stuff that you're not allowed to do with business names. You cannot imply association with somebody else. You cannot risk confusion and the rest, but things are a little looser. You do not need to display your business name in the same way that you would display your company name. Company names, though, are part of mandatory disclosures. For instance, you will find both in sections of the Companies Act plus in other places, we've got, for instance, the company's trading disclosure regulations, and there are two sets in 2008 of statutory instruments that give you this. It says what sort of information about your company you need to make available to people and where you need to put it. Every company must display a sign with its registered name. It needs to have the address of the office and the location at which it carries its activities. And also, you must sign all documentation on headed paper with this information. What's the name of the company? What is the registered address? What is the company number? And on certain types of documentation, you need also to put the names of the directors. Why do we have these disclosures? Because it's important for people to be able to see who is behind the company that you're working with, right? Because a company name could be anything. And you might, if somebody comes and proposes a business deal to you, you should be able to check who is the actual person behind the company to verify that the person that you've been talking to is in fact associated with that company. These things are free to check on the Companies House website. So you can either put the name of a person and do a search with their name, or you can put the name of the company and then it will tell you where is its registered place and what are the names of the directors. Can you have something that looks like a website as a company name? Yes, you can. But again, don't make the mistake of confusing domain name registrations with company name registrations. You're trying to book a ticket, say, you very good offer on a ticket online and it's sold by Yorgos and George travel agents. Is this just like a fake website that's going to take your money and you're never going to hear from them, or is it the real company? They need to display their company number. They will also might display that they participate in various travel agent related stuff that offer insurance and protection and so on. It is in your interest to check these things when you're doing business with somebody, to check that they actually are who they say they are. Considering so much of business happens online now or over the phone, you need to be sure that you're not talking with somebody else who's trying to scam you. If you're reckless, then you might suffer the consequences of your recklessness, in the sense that you've paid a lot of money and you didn't get what you ordered. Some of these requirements apply to overseas companies that operate in the UK. There's a basic level of information that needs to be available for all companies, including overseas companies, again, so it allows you to check who you're dealing with. And foreign companies also need to have an address in the UK from which they do business, for the primary reason that if you need to serve them court documents, you know where to send them to. What do you need in order to set up the company and to have it operating? Well, you go online, pick up an application form, fill it in, pay the fee, put together memorandum of association, articles of association, and any additional information. Now, you might need the additional information to explain your choice of name, for instance. If it looks like it's violating any of the provisions there, you might want to explain further why you're choosing a name that kind of looks like it might not be appropriate. And then this is how much it costs. This is just an illustration. These things kind of change all the time, right? But it gives you an idea. So in this country, it's relatively cheap to set it up, and you can do it pretty much on a day. So basically, the only thing you need is to have the documents prepared in advance, have your credit card, bam, you go on the website, get it done, you're up and running very, very soon, and it doesn't cost you much. 120 pounds or so. I think this includes the fees of that particular website. Now, in Germany, you can see it takes a little bit longer, and costs significantly more. Now, in other jurisdictions where it doesn't take that long, it still costs a lot of money. But again, these things are subject to change. But you would normally expect it's going to cost you a significant amount of money. This has to do with capital requirements where you're setting up and so on, in addition to administrative fees. These things are fairly low in the UK. You need to be aware of these things. And this is a good way to assess how business-friendly a jurisdiction is. The lower the bureaucracy, the lower the cost, the faster it is to get something set up. It suggests that this is a friendlier business environment. Now, if you need to pay lots of money, takes a very long time, you need to visit 15 different guys with mustaches to stamp a document before you get started going, less business-friendly place. And finding information about the companies, the company will receive a certificate of incorporation. From the point that it receives the certificate of incorporation, it is allowed to engage into business, and you go to the company's house website where you can get a lot of information. Now, the steps to obtain the certificate of incorporation are slightly longer for public companies, because you need also to make a more significant capital investment at the beginning. The capital thresholds are much more significant for public companies, so you need to pay that money first and then you get your certificate. In any case, the company is prohibited by law to engage in trading before they have obtained this certificate. If they do engage in trade, then the people doing it become personally liable. So you cannot hide behind the veil of incorporation if the incorporation has not happened yet, and the incorporation has not happened till you had your certificate. So if the company attempts to engage in any business, sign any contracts, then the people signing them are the ones directly responsible. The company could choose to adopt those, to ratify them, subject to, after incorporation. This is fine. But if it doesn't, then it is a personal problem for the people who were signing. If we find anything wrong with this process, what can you do? Well, the act of setting up a company is final. Because once they get the certificate and they start doing business, it would really be extremely disruptive if you came back and said, oh, hang on here, we made a mistake. We shouldn't have registered those guys because there's something wrong with the name or there's something wrong with something else. Nobody can challenge the act of incorporation. It is only the Crown itself, it is only the judicial authorities of their own initiative that they can challenge the act of incorporation if they find that something has gone horrifically wrong and it wasn't spotted before they got the certificate. But no private individual can challenge the act of incorporation. What you do instead is that you wind down the company. It means that the company existed, carried out some actions, then it's getting dissolved. So for the time that it was actually operating, it had valid authorization to operate. So then any rights and liabilities created out of this need to be sorted out the normal way. If you undo the act of incorporation, it means the company never existed, which means that if it has signed contracts, in the meantime, you don't know what to do with them. So it is believed that the best way to deal with this, instead of undoing the act of incorporation, is to wind them down using the normal process that you're going to find, the Insolvency Act and so on. Of course, many things are subject to change, and the most important changes normally are not about changing the name, but they're about changing the type of registration. And the Act gives you that capacity. You can go from a private company to a public company, but you can also do it the other way around, right? A public company can become private. You can go from limited to unlimited, but also the other way around. And you could go all the way down. You could be a public company in the stock market, delist from the stock market, then go from public being private, and then go from private being unlimited. But a lot of people do this, from public to private. If you're a public company, you've got a lot of shareholders and you do not necessarily control the general meeting and you don't control the voting. So if you want to carry out an extreme restructuring, then it might make sense to take the company from public private. You buy the shares from all the shareholders and you hold them yourself. Once it's private, decision making is a lot more streamlined and the intentions of the shareholders and the management are much more aligned. You take the guts out of the company, you do whatever you want to do, reframe it into something else. Once you're done, relaunch it as public and get investment in it. This happens usually by private equity takeovers. Right? Private equity firms have got a lot of available cash. They identify public companies with a problematic profile or problematic operations. Get a substantial share, then use this to control the management, then use this to take the company from public to private hands, restructure the hell out of it, and when it looks like it's got better chances of being profitable, then they put it back as a public company and invite investment. It normally doesn't work well for the company in the long run because in the process of those changes, the company tends to get a lot of debt. It's all this discussion about debt, leveraged buyouts, and so on. But this ability to re-register from one type of company to the other exists in the law and it is often used. You've got some cases here that give you illustrations of how to deal with problematic incorporations. Our register of companies was about undoing a registration of this lady there. This was a pornography business. They registered something that looked like it was meant to carry out inappropriate business of that nature. And then they went, we registered the company here in order to carry out this thing, and this is not very nice, so what we should do? And it gives you an opportunity to look at the process where the Crown itself takes initiative to deregister a company. So this is an example of hitting something bad. You've authorized the company to do something that really is not supposed to be happening. So that way you should just not wait for the company to engage in operations and then dissolve it. So it means you want your hands clean of this, so this company never existed to begin with. So this is a good illustration about how you do this.